I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame. Today, we are going to be jumping into our 35th compilation video. I just want to shout all of you guys out for all of the support on these videos. I am glad that for many of you, a lot of these proceedings that we shared earlier on the channel, probably because of YouTube's algorithm, sometimes they show some of the older stuff, sometimes they don't, or sometimes they show it to specific people, but it's been getting out to the right people, to the people that haven't seen it. So that is a great thing for us all. And with that being said, we're going to be in 3 different judges' courtrooms today. Before I give you that rundown, let me just give you a little announcement. First and foremost, there will be no commentary at the end of these proceedings. And second, there will be chapters added just in case you've seen any of them or you just want to jump around. With that being said, let me give you this rundown. The first courtroom we're going to be in is Judge Donald Coleman out of the state of Michigan. Second, we will be in the courtroom of Judge Stephanie Boyd out of the state of Texas. And last but not least, we will be in the courtroom of Judge Tammi Hayward out of the state of Georgia. So with that being said, these are some classic moments once again from earlier here on the channel. Just bringing them back, throwbacks. And for many of you that haven't seen it, it's going to be a great thing. For those of you that have seen it, it just might be one of those, those moments to remember, that we're just bringing back to your recollection. But wherever you fall, I'm pretty sure you're going to enjoy these videos. So with that being said, guys, let's go ahead and jump into this compilation.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on this Zoom? Say something if you're here at this time.
Yes, Your Honor. Javar Grayson representing myself.
All right, thank you, Mr. Grayson. Good morning to you as
Good morning.
well. So, all right, I see that there is the, let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on the one hand, you're telling me that the court doesn't have jurisdiction. You telling me that the court doesn't have jurisdiction, and you're not submitting to the jurisdiction of the court. Then why are you filing something in this court if you believe the court doesn't have jurisdiction? You filed
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you
Yeah,
talking about?
yeah, sir.
So,
And we
let me go to
understand
the,
that.
all right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who is representing this police officer filed its motion back in June, dismiss in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this case under any of those grounds.
Well, certainly, let me begin with the default request. I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. Now, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file straight, that if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is a some type of traffic ticket. I started off Brian Ambrosius stopping me, and I believe I have the right to travel. It started with that, and I do understand the default judgment. What do you that you are saying, and what it's pertaining to. We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's actions being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
All right, Mr. Michael, you get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiff. And it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing my right to travel.
All right, I got it. All right, that you failed to state of action upon which the court can grant relief. This case and the complaint in this matter will be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter. Again, the complaint is dismissed without prejudice. That would be a final order regarding this particular file. Good day to both sides. I wish you well.
Hello, how's it going?
Could be better.
All right, so my understanding, you want to represent yourself? All right, you're more than welcome to represent yourself, but here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules. So let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I'm the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me.
Mhm.
There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're gonna get you a copy of the indictment. Just give me a moment. All right, have a seat. We're gonna come back on the record with this.
All right.
So we're back on the record in 2024 CR 2974. State Vex versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for. So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness, you need surgery, and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right, Norma, get someone from manage to sign counsel here, please. All right, just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right, so let the record of the court show that I, Hector Casanova
Just one
Jr.
second.
The accused
Just
in
one
the
stop.
Yes, sorry.
All right, we're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action. Furthermore,
let me
let the
stop you.
record also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment, and the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So This being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from managed assigned counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent.
Mhm.
I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under.
Mhm.
Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under.
All right, I'm going
admiralty or
to
military
counsel,
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for managed assigned counsel, period. That's it. So have a seat, managed assigned counsel will come over. Do you understand? Yes or no?
I do not understand.
All right, do you understand what it means to take a seat?
I do understand.
All right, so take a seat.
Yes, ma'am.
Thank you.
Of course.
We have talked.
Mhm.
I've informed him that I'm here, to help him in whatever he needs help with.
Mhm.
He's gonna consider what help he thinks it might need from me, and I know he wants to put something on the record.
Okay, all right, and so you'll be appointed as standby
Yes.
counsel then?
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing, so.
All right, we're going to go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. Yes. All right, so Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
Yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right, who threatened or coerced you to come to court?
The county of Bear, Texas.
How
State.
so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date and you can accept the state's offer, come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date And then you'll sign it, Mr. Bach will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome. And thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
Mr. Resto. So Mr. Resto, you have two cases. You have case number. You hear me?
Yes,
Okay.
I hear you.
So you're before the court on 2019 CR 04954 for driving on a suspended or revoked license, no license, failure to display license, or failure to have license on person. I'm not sure, it cuts off, and no tag or expired or invalid tag. So that's on the first case. On the case from 2020 03114, you have a suspended or revoked license. You're represented by Lister and Holt on one of the cases, but not on the other. Did you want Lister and Holt to represent you, or did you want to represent yourself?
I represent myself.
On both cases?
Yes, ma'am. I have a quick question as far as locker term when it comes to driver's license.
Okay.
Okay, you're only allowed to have one driver's license, and I have an Alabama driver's license. So when I get pulled over, I actually showed them my Alabama driver's license, and it's current. It's the most current, and so they make a determination if they should go off the Georgia driver's license or the Alabama driver's license. And when I present the Alabama driver's license, they let me go because my Alabama license is valid. And you're only allowed to have one. And I had Alabama license first.
Honor,
So my
I believe
Georgia
this sounds like a not guilty.
Okay. So Mr. Resto, what Mr. Taylor is saying is this is something that you could prove at trial. If you present that information at trial, then that means you want to go to trial instead of taking a plea. I don't know what the recommendation is, and I don't know.
Well, the recommendation was, I think I've been dealing with this case for an awful long time now. So
Yeah.
I don't really want to go to trial. I just want to get it behind me. But I think that I remember the recommendation quite clear. They offered me 40 hours of community service. Is that still on the table?
Okay, no, Mr. Resto, it's more than that. So let me explain why I know it's more than that. So the basic fines and fees for driving on a suspended license is the first time in 5 years. If you get one, then you can enter a NOLO plea if you have a NOLO plea eligible to you. And then the fine is $500. But if you get a second one, the fine goes to $1,000. A third one, the fine goes to $1,500 and 10 days mandatory jail time. You have a second one, which means that you might be able to enter a NOLO to the first one, but then the second one is outstanding. So when you took a plea to the second one, that would definitely suspend your license. So that's what's on the table.
Okay.
And the fines are hefty. So you would get a plea on the first one, and that's a $500 fine, which is $737.50. But the next one is going to be $1,000 in addition to that, and that's $1,420. So we're looking at almost $2,200.
Your Honor, is Mr. Resto represented on the particular case that we're referring to?
Well,
I want to address him directly if he's represented, because this is a serious matter.
I get you. So that's why I'm saying, Mr. Resto, you have representation. I can allow you to be represented on both cases, and they can help you work this out. But understand
well, I was already represented by Lister and Holt, and we kind of been going back and forth with the district attorney's office for a while, and they've been giving me recommendations, and I still didn't take it, but they've been giving me recommendations. I don't know what's changed, but it definitely wasn't $2,000.
talk to your attorney and let them tell you what the recommendation they have on the table, okay? Because the recommendation, if you're represented, even if you're only represented on one case, the rec is probably going to come to your attorney.
Okay, now if I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
Okay,
Or
I'm not sure what that is. So I have taken an oath to uphold the Constitution and to make sure that I treat people as the law would direct me to do so. So,
okay, well, I asked this question previously when I was in your courtroom one day in regards to the right to travel under the 14th Amendment, stating that citizens do not need a permit to travel with a horse-drawn carriage, wagon, or automobile without interference by police. And I was on a public highway actually when I got pulled over.
Okay, so that's not actually in the Constitution.
And
So
I don't
right
believe
to travel,
automobiles were around when the 14th Amendment was ratified.
I'm sorry, go ahead, Mr. Taylor.
I just wanted to point out to the court that automobiles hadn't been invented when the 14th Amendment was ratified. That
Yeah,
may
it says automobile, horse, drawn wagon, or carriage.
Okay,
so an automobile is not necessarily a car if it's a household good. It's just a form of transportation. It doesn't matter if it's an automobile, horse, drawn wagon, or carriage, because it's still a form of transportation, and citizens have the right to travel without interference by police. So I don't even know how the police are even allowed to interfere with travel when I'm not using my vehicle for commerce.
Your Honor,
and it's
hold on, Mr.
totally
Taylor.
private household good.
Okay, so Mr. Resto, if somebody drove 100 miles an hour into the back of your vehicle and killed your a family member, would you want the police to interfere?
That's murder. I mean, that's if someone got killed.
But they're traveling. You can't interfere with somebody traveling.
No, I mean you can't. It's stating that a police just can't interfere with your traveling, like pulling you over for a traffic violation or a tag.
But you want them to interfere if somebody.
Now, if you murder somebody because of
say you don't murder them. Say you just hurt them. Say you just damaged the vehicle. You don't want the police to interfere.
No, that's when it almost becomes like an accident or a crime or whatnot. So the police can. That's not really an interference. An interference with your traveling, not an interference when two citizens engage in an accident. It's interfering with you just traveling. Now, police officers, as far as public servants, they have a duty to serve to the people. So if a car accident occurs, then of course public servants, as far as ambulance, as far as firemen, they will come to the scene just as a service. But for you to just interfere in my traveling is actually a violation of the Constitution.
Well, sir, the Constitution and the cases that have come out of the constitutional jurisprudence allow cities and states and municipal organizations to regulate travel for the benefit of the citizens. So they can put reasonable regulations on travel, meaning you can have a license. They can grant you the privilege of having a license to drive. They can regulate how your license is seen. If you don't have a license, or if your license is suspended, they can intervene to take your license away or your privilege to drive away. It is a crime. You can be convicted of not driving under a proper license. So the government is allowed to intervene in a lot of ways with people traveling. So I'm not sure where this information comes from, but there's a lot of stuff on the internet about traveling and the 14th Amendment and horse and buggies and even maritime law. But
I mean, an automobile was actually created before a driver's license was ever created. So people was actually operating their case pamphlets where people was actually operating vehicles before a driver's license ever became. That's actually, you guys are actually a conflict of interest, actually, as far as you being in cahoots with the DMV. That's a totally separate entity.
Okay,
And for
so
some
Mr.
reason,
Resto, do you want to resolve the case? Because it's not
I
going to
want to
be
resolve the
40
case, but
hours of,
I disagree with the fine amount because it changed. I would
it,
pay I would make an offer like I can do $1,000, maybe 12-month probation, but
Mr. Resto.
$2,000 that's excessive.
Mr. Resto, we're not negotiating. Those are statutory fines, meaning they're written into the law. I can't even change them.
Can I make a counter offer to the state and say it's $1,000? That can I be?
No,
Because I did do
sir.
time in jail. If the state would see that
Well,
and count.
that's why I'm saying that you may want to speak with an attorney because certain things that they can negotiate, I can't change the statute. I can't change what's written in it, but they can negotiate. And if the solicitor wants to give you credit for time in jail in lieu of the fine, those are things that they can do that I can't do.
Yeah. So I would ask to the district attorney, knowing that I did serve some days in jail, can you guys
Okay.
lower the fine and I just go ahead and end this
So,
case right now? I can do 1,000. I got $1,000 right now.
Mr.
And
Resto, so that's a conversation that you need to have with them directly without me being present, number one. Number two, the reason I keep saying you might want to go through your attorney is because they can explain to you what is already on the table and how that may or may not change, okay?
what's on the table now?
I don't know. That's what I'm saying. I would rather you have that conversation in a breakout room with the attorney who's assigned to your case and with the state as opposed to here in the main room. One, because I have other cases that need to be addressed, and two, because that's not information I need to hear.
Okay, is it anything I can do to get this case resolved now? Because it's been lingering on
I'm
my
telling
head
you what to
for
do, but you're
years.
not listening, Mr. Reston. Mr.
I mean,
Resto,
today, like I want to resolve this today.
I get that you want to resolve it today, and I'm telling you what to do, but you're not listening to me. I said you can go into a breakout room with your attorney, and the attorney and you can discuss what's already on the table. And then if your attorney wishes to speak with the state to clarify anything, they can do that too. But you're not going to get it resolved by going back and forth with me because there's stuff I cannot do.
Okay, just tell the state that I'll take their recommendation. I'll just pay the $2,000 if they can give me 12 months to pay it off. And
Okay,
if I
but,
can, and if I pay
sir,
it off early, if my probation would be terminated, that would be great.
Sorry, I was discussing with Mr.
Resto?
Resto, and I understand something changed about his bond.
Okay. He has bonds with two bondsmen. I don't know of anything. Did somebody come off a bond?
Your Honor, maybe I can address that question.
Okay.
Mr. Resto, our office filed a motion to revoke bond, and that motion was granted a rule nisi, and it was calendared. That motion didn't happen because of the pandemic. It was, I believe, scheduled to happen in 2021, maybe February, but somewhere about that time. I informed Mr. Kamani to inform his client that depending on the outcome of today's arraignment, the state intends to move forward on that bond revocation. Your Honor, may I make a request on that matter?
Sure, Mr. Taylor.
I'd request that the defendant show in person for him. Zoom court is or remote appearance is not sufficient.
So it's my understanding that you and Mr. Castaneda have parted ways with respect to your case.
Yeah. Did he file a motion to withdraw?
Yeah. Did you want to go forward without an attorney representing yourself?
Yeah, it seems like the attorneys that the state appoints me, they have a very hard time of like listening to their clients, like what they have to say. Like I had a conversation with him for like maybe 5 minutes, and he was very like wanted to do what he wanted to do. He didn't want to hear what I had, or he was just telling me like I was raising concerns about the state came off of my bond, and I was trying to figure out why they came off of my bond when I show up for court. I gave him no reason to come off my bond, and he said,
so when you say come off your bond, The bonding company has to do that, not the state. So I'm not sure, like,
Well, they
what
filed
happened.
they filed a motion to come off my bond. That's what he stated.
Okay, is that Free at Last or Atlanta Clayton bonding?
No, not Free at Last. It
So
was.
I have that you.
He stated that the state filed a motion with your court, stating that they wanted to come off my bond to where basically I will have warrant on me.
Okay, Miss John VA, do you have any outstanding bench warrants for Mr. Resto? I don't recall signing any, but I may have.
Did the state file any motions in regards to that?
No.
Okay, I did. So just one moment, Your Honor, I didn't know that he was back. I'd already given the file to my assistant. She said she had just sent off the bench warrant to you as well, I think. So
I didn't think.
Okay.
All right. So yeah, Mr. Resto, you're here. So I haven't signed anything yet.
Okay. Does the state have any intentions on trying to come off my bond?
No. So, sir, they don't come off your bond unless you fail to appear. My understanding is you had a medical excuse for being late today. So you contacted
I'm actually still at the hospital. I just had a minor surgery.
Okay, so Ms. Val has allowed you to come on to the call today because she knew that you had a medical issue. So we can deal with your case today, or we can give you a continuance until December 6th, but nobody's coming off the bond and the bench warrant will not be signed.
Okay, I want to handle this today. It's kind of been lingering over my head for some years now. I'm really tired of it. And but I hear that the state is trying to give me 10 days in jail, and that would absolutely ruin my business, my life.
So
I have a 2-year-old son, and I'm a single father. Yeah, but see, Judge, in my situation is okay, I got the documentation from the Alabama motor vehicle department. See, I'm actually an Alabama citizen.
Hold on, Mr. Resto. Hold on. Let me put you in a breakout room with me and the state so we can hear what you're saying, but we're not putting it all out there in case you want to make a different decision, okay?
Okay. Well, I have no absolute reason to lie, and I really believe
No, it's not that, sir. This is what I would do if you had an attorney who was representing you, okay? So this is called a pre.
Yeah, but I just honestly believe that when you're just being truthful, there's really no need for attorneys when you're just being honest about your situation.
Next is Mr. Resto. Mr. Castaneda was fired by Mr. Resto, so he's no longer counsel of record. Mr. Resto is wanted, and there is no surety on that. Does the state have there's no surety order on that? Does the state have a request in the Resto case?
Mr. Resto, yes, state would definitely request a rule absolute on that matter.
Okay, on both cases, a rule absolute will be granted.
I'm not threatening you. Say one more word and that's 30 days. 30 days.